Hi everyone, my name is Marina Kinsey and this is my law case presentation for ATE 3515, Legal and Ethical Issues in Vet Med. Today I'm going to discuss a very important legal battle between the Missouri Primate Foundation and People for Ethical Treatment of Animals, also known as PETA. This case spanned from 2016 into the early 2020s with the litigation and enforcement lasting about 7 years. This case is especially important because it addresses how the Animal Welfare Act and Endangered Species Act interact when endangered animals are kept in private facilities. The Missouri Primate Foundation is a private breeding and boarding facility that bred and housed chimpanzees for entertainment, exhibition, and private ownership. They were previously licensed under the Animal Welfare Act by the United States Department of Agriculture. The Animal Welfare Act is the primary law in the United States that regulates the humane treatment, care, and handling of certain animals. The USDA is the federal agency tasked with administering and enforcing the Animal Welfare Act to minimum federal standards of housing, husbandry, feeding, watering, sanitation, and ventilation. The concept of minimum standards becomes particularly important in this case because one of the main legal questions was whether the Animal Welfare Act was sufficient to protect the facility from liability under the Endangered Species Act. Under the Endangered Species Act, a 60-day written notice of intent to sue is a required legal prerequisite for citizens and organizations looking to file a lawsuit against alleged violators of federal agencies. The purpose of there being a 60-day notice is to allow time for evaluating claims, negotiating a settlement, or correcting violations before an official lawsuit is filed in court. In November of 2016, PETA and former Missouri Primate Foundation volunteer Angela Scott sent a notice of intent to sue to the Missouri Primate Foundation, its owner, Connie Brown Casey, Andrew Sawyer, owner of chimpanzee Joey, who was housed at the foundation, and Jane Does 1 and 2, both owners of chimpanzees Allie and Chloe housed at the foundation. The Endangered Species Act is the primary federal framework that is designed to protect critically imperiled species from extinction. It classifies species as endangered or threatened. The notice of intent to sue that was sent to the Missouri Primate Foundation details the chronic ongoing violations of the Endangered Species Act. The Endangered Species Act also prohibits the take of any listed species. Under the law, take means to harass, harm, pursue, hunt, shoot, kill, wound, trap, capture, collect, or to attempt to engage in any such conduct. The notice also challenged Sawyer and Jane Does 1 and 2 in their take of the chimpanzees they own unless they are placed in reputable sanctuaries. The notice also states that PETA has arranged for transport, sanctuary placement, and veterinary care should the Missouri Primate Foundation and the other parties involved wish to correct the listed violations. PETA and Scott alleged that the chimpanzees were kept in conditions that caused physical and psychological harm. Many of them were kept in cages that lacked vertical and horizontal space, which limited their ability to move naturally. Many of the chimpanzees were housed alone, which resulted in limited social interaction, despite being highly intelligent and social animals who normally live in complex family groups. The notice also alleged that the chimpanzees lacked environmental enrichment and ability to engage in species-appropriate behaviors. Additionally, PETA described unsanitary conditions including accumulation of feces, urine, flies, roaches, rodent droppings, high levels of ammonia, and moldy food accumulation in their enclosures. PETA argued that these conditions constitute harm and harassment under the Endangered Species Act, and therefore amounted to an unlawful take of an endangered species, which violates the Endangered Species Act. Before the 60-day notice of intent concluded, the Missouri Primate Foundation filed an initial lawsuit against PETA. The lawsuit was seeking declaratory and injunctive relief. This means that the Missouri Primate Foundation was seeking declaration that it was not violating the Endangered Species Act and to prevent PETA from proceeding with its claims. The Missouri Primate Foundation also had a third claim alleging defamation, arguing that PETA's public statements about the facility harmed its reputation. PETA filed a motion to dismiss these claims and filed a counterclaim under the Endangered Species Act. In this stage of the case, the federal court granted PETA's motion to dismiss all three claims brought by the Missouri Primate Foundation. The court dismissed the declaratory and injunctive relief claims because it found that it lacked subject matter jurisdiction to decide those issues at that procedural stage. The defamation claim was also dismissed because the court found that the Missouri Primate Foundation failed to state a legally sufficient claim. Importantly, the court did not make a final determination on whether Missouri Primate Foundation was actually violating the Endangered Species Act at this time. Instead, the case continued forward under the separate Endangered Species Act claims brought by PETA. One of the key legal issues in this case is the relationship between the Endangered Species Act and the Animal Welfare Act. The Missouri Primate Foundation's argument was that the PETA's claims were based on conditions that fall under the Animal Welfare Act, which is administered by the USDA. They claimed that the Animal Welfare Act regulates the housing and care conditions for captive animals, and that the Endangered Species Act should not be used as an alternative enforcement mechanism. The court rejected this argument and considered the Endangered Species Act to be complementary with the Animal Welfare Act. The Animal Welfare Act sets baseline care standards for animals, while the Endangered Species Act provides additional protections for animals that are considered to be endangered or threatened. Therefore, the court concluded that the Animal Welfare Act does not shield from liability under the Endangered Species Act, and captive endangered animals remain protected from unlawful take. And if you think the story ends here, no, it does not. Early in the litigation, the Jane Doe defendants agreed to surrender their chimpanzees, Allie and Chloe, to accredited sanctuaries, which was the remedy originally sought by PETA. However, litigation continued regarding the remaining chimpanzees housed at the facility. In 2018, ownership of those chimpanzees was transferred from the Missouri Primate Foundation to Tanya Haddix, an exotic animal broker involved in the private primate trade. As a result, PETA amended its counterclaim to add Haddix as a defendant in the case. PETA continued to allege that the conditions under which the chimpanzees were housed constituted an unlawful take under the Endangered Species Act and continued to seek sanctuary placement for the remaining animals. In 2020, PETA negotiated a consent decree with Haddix, allowing her to keep 3 of the 7 chimpanzees in her custody if she met specific care and housing requirements. The remaining 4 chimpanzees were to be transferred to an accredited sanctuary. Haddix failed to satisfy most of her obligations, and in 2021, a court order to show cause and schedule a hearing was initiated. Tonka was one of the several chimpanzees in Tanya Haddix's care. He was previously used in the entertainment industry and can be seen in films such as George of the Jungle and Buddy. Immediately after the order to show, Haddix claimed that she had found Tonka deceased and that she and her husband disposed of his remains in a fire pit. At the hearing in 2021, Haddix failed to provide any evidence that he had actually died. The court ordered that all 7 chimpanzees, including Tonka, be transferred to sanctuaries. Haddix then filed an appeal with the U.S. Court of Appeals in the 8th Circuit. When PETA arrived at the facility to collect the chimpanzees, they noticed that Tonka was nowhere to be found. At another hearing in 2022, PETA had expert testimony stating that the way Tonka's remains were allegedly burned was a physical impossibility. The court held Haddix in contempt because it found that she intentionally violated court orders by falsely claiming that Tonka had died, concealing his location, and failing to comply with the court's orders regarding his transfer. Contempt of court is when someone willfully disobeys a court order or shows disrespect for the authority of the court. PETA received a tip that Haddix was keeping Tonka in her basement and was planning to euthanize him because she believed he was suffering from congestive heart failure. PETA submitted an ex parte motion for a temporary restraining order to prevent Haddix from euthanizing him and from moving him from his current location. When the U.S. Marshals served the order on Haddix, they confirmed that Tonka was in fact alive and being kept in a small cage in her basement in poor conditions. After his rescue, Tonka was evaluated by veterinarians and was found to have no evidence of congestive heart failure. He went on to live among other chimpanzees at a reputable sanctuary. The court ordered Haddix to pay approximately $225,000 to reimburse PETA for attorney's fees and costs incurred resulting from her contempt of court. In 2025, Tanya Haddix pled guilty to 3 felony charges, 2 counts of perjury and 1 count of obstructing justice for making false statements under oath during the federal and court proceedings. She was sentenced to 4 years in prison. She has filed an appeal for a sentence reduction, but there has been no indication that her sentence has been overturned or that she has been released. I had never heard of this case before, and to my surprise, it was much more involved and interesting than I had previously thought it was going to be. But after reviewing the facts of the case and the court's decisions, I do agree with the rulings made. I believe that the court made fair decisions that upheld the protection of the Endangered Species Act and prioritized the welfare of the chimpanzees. I also agree with the court's handling of the consent decree violations and the contempt proceedings involving Tanya Haddix. Once the court determined that its orders had not been followed and that Tonka had been concealed, additional legal intervention was necessary. I believe the final outcome brought justice for Tonka and the other chimpanzees by allowing them to live in accredited sanctuaries where their physical, behavioral, and social needs could be met. I think this case helped bring national attention to the ethical treatment of captive primates. The events surrounding Tonka became so well known that they were later featured in the HBO documentary Chimp Crazy, which I have yet to watch, but I plan to. But it introduced it to a broader audience, the challenges of enforcing animal welfare and the endangered species laws. I really hope you enjoyed my presentation. I enjoyed this project and researching this topic. I think it's very important. But thanks.